What is a claims-made policy and how is it different from an occurrence-based policy? So an occurrence-based policy is a policy where coverage is triggered when an incident occurs during the period of insurance. And it is generally designed for general liability policies, umbrella policies, and commercial auto policies. The difference between that and a claims-made policy, a claims-made policy is when a claim is made during the policy period, as opposed to an incident occurring during the policy period. The difference is it's a shorter and more predictable time frame typically as to when something arises and when the insured is required to notify the insurance company of it. So typically in a claims-made policy, the claim needs to be made against the insured during the period of coverage. And most often that claim will need to be reported during that period of coverage, although policy language can differ on that. An occurrence-based policy, the incident could occur at any time, as long as it was during the coverage period, and the insured could learn about it much, much later in time, and it could still be covered. So as long as the incident itself occurs arguably or factually within the period that the coverage was written, it doesn't matter when it is that the insured learns about it. So what's a classic example of that? Well, one of the things that's been going on around the country right now is all these sex abuse cases that have come up where states have revived the statutes of limitations and allowed injured people to bring claims against people that they believe are responsible for some type of sexual abuse or misconduct. So you have church cases and school cases, and you have the Boy Scouts. You have all kinds of different cases that have been revived by legislative fiat. And what happens in those particular circumstances is the alleged conduct typically occurred many years ago, which is why the statutes have been revived by the legislatures to allow these people who were injured as children to now make claims. Well, if the defendant or the insured to those claims had a policy and the allegations of the alleged injured victim occur, say it occurred during, let's say, 1953, and a policy of insurance was issued to that insured in 1953, that is going to have an argument that it's going to be covered under the policy because the incident occurred during that time frame. And that's what occurrence-based insurance is. Similar for like environmental claims, that where something was leaching into the groundwater over a period of years. That can go way back in time. So it's not necessarily just your ordinary automobile accident or some type of other incident that occurred right in the middle of the policy period and you have to notify them right now. It could go all the way back into the past. That's not going to be the case for a claims-made policy. The claim's going to have to be made during that policy period, whether or not the incident occurred during that time of the policy period. And that's going to be the significant difference between claims-made policies and occurrence-based policies. What types of policies are typically claims-made policies? Well, the vast majority of coverage for businesses these days is in the form of claims-made policies. So general liability policies, umbrella policies, and commercial auto policies are typically occurrence-based policies. So you could pretty much think about all the other coverages that you might have as a business owner as being claims-made policies. For example, errors and omissions policies for brokers, professional liability policies for architects, engineers, attorneys, directors and officers liability policies, employment practices liability insurance policies, cyber coverage. A vast majority of these types of policies are going to be claims-made policies. What constitutes a claim under these claims-made policies? Well, that depends on the type of policy you have. So I have with me two different samples just by way of illustration for this type of thing. The first one is a professional liability policy, a legal malpractice policy. And under that policy, I'm going to read for you, a claim is a written demand for monetary or non-monetary relief received by the insured during the policy period including the service of suit or the institution of an arbitration proceeding. That's the definition of, and that's a typical definition for a professional liability claims-made policy. It is a written demand for monetary or non-monetary relief, and then you get into what is monetary relief versus non-monetary relief. Clearly, if an insured receives a letter from a client that says, you made a mistake and you owe me $500,000, that's going to be a claim for money. And the duty of the insured, the lawyer that receives that, is going to be to put the insurance company on notice of that claim. Non-monetary relief could be a different thing. In the lawyer's world, quite often that is a demand for services. You promised to bring a lawsuit on my behalf and you didn't do it. I demand you do it now. That would constitute a demand for services or non-monetary relief that would trigger the obligation of the lawyer to notify their claims-made professional liability insurance company. In another example, which is much broader, I have a directors and officers liability policy. And here, there are many different things that can constitute a claim. And I'm going to read for you. Claim means, first, an oral or written demand, including any demand for non-monetary relief, which is very similar to what we just talked about with the professional liability policy. Next, number two, any civil proceeding commenced by service of a complaint or similar pleading. 3, any arbitration, mediation, or other similar dispute resolution proceeding. 4, any administrative or regulatory proceeding commenced by the filing of a notice of charges, formal investigative order, or similar document. 5, any criminal proceeding commenced by the return of an indictment, or 6, any appeal from any proceeding referred to in this definition. So you have very specific listing of the different types of proceedings that can constitute a claim under a D&O policy. And in the world of what can be even further interesting, some policies will contain a rider or contain some additional language where they will say, and in this particular policy, it says if you are in the receipt of a target letter from an institution, and target letter has a very interesting connotation as to what a target letter is. But a target letter typically can be interpreted as a letter received by some type of a state or federal investigatory body. So such a target letter could trigger an obligation to provide notice of a claim. In addition, receipt of a subpoena, quite often under that definition, will be considered some form of a target letter or document that would qualify you for coverage under the D&O policy, but also require you to notify the insurance company. What constitutes a potential claim under these policies? And this is opposed to as the definition of a claim. So this comes up in my experience as a practitioner representing insureds, most often in the context of lawyers. So, but it can come up in the context of brokers and other types of professionals, architects, doctors. Okay, so think of a doctor that realizes after a surgery that they left some type of gauze inside the patient when they sewed him up, or they left something in the patient's body, or they did something that they know was wrong under the during the procedure. If the policy requires that they notify of a potential claim or circumstances that could arise leading to a claim, then they may have an obligation to put the insurance company on notice. And as I said, this happens a lot with lawyers, because lawyers so often make mistakes or do something that they can fix pretty easily. Now, certain things as a practicing lawyer, I can tell you can't fix very easily. For example, blowing the statute of limitations, you can't really fix it. Blowing the time within which to file a notice of appeal, you can't really fix it. You blow that, you pretty much have the reasonable possibility that a claim is going to be made against you. But other things become more subtle. And there are mistakes where I very often, both internally in my own office and counseling clients on a regular basis, go back to the language of my policy and say, is this a mistake that could possibly lead to a claim being made against the firm, which would require me to notify the insurance company? And that's a big difference between just, hey, I know this is a claim. I got a letter. I got a lawsuit. Somebody commenced an arbitration against me. I received a subpoena. It's more like, hey, I was doing something internally and it looks like there's an error. And now I need to think about whether that's an error that is of a magnitude that it could lead to a claim such that I've got to put my insurance company on notice. And so I would say probably professionals is the most likely scenario where you're going to see that, and lawyers, it's a debate all the time. Not saying that people run rampant making mistakes, but the practice of law is called the practice of law for a reason. Everything procedurally can change. Every set of facts can be different. Every strategic maneuver could be different. And so it doesn't mean that you're in a daily assessment of whether you've made mistakes that require you to notify the insurance company, but scenarios do come up during the course of a practitioner's life where they have to perform that evaluation. And the beauty of a claims-made policy is if you notify the insurance company of a potential claim, as we're describing here, the policies that will then typically say if the claim comes in later, and it's after the policy period has expired, and after any extended reporting period has expired, that potential claim becomes a claim, it will deem to be covered under the policy because you notified the insurance company about it, even if it didn't come to fruition, the lawsuit or the arbitration or the whatever proceeding didn't happen till later, it's going to be considered a covered claim. What do I need to know about past and future claims as it relates to these policies? Well, for starters, when it's claims made, if you have not notified the insurance company of a claim, the policy has expired and you no longer have coverage with that company or you renewed with another company, any claim that comes in after that is going to be deemed to not be covered. It's too late. And that's why claims-made policies are structured the way they are, to keep premium costs lower and to allow insurance companies to engage in more exacting and efficient underwriting, because they know that they have a time period where their risk is going to be, they're going to be on the risk and then they're going to be off the risk. By the same token, prior claims, if they're not subject to an exclusion where they just say any prior claims are excluded, then prior claims that you knew or had knowledge of in some way, shape, or form that lead to a claim during the policy period are also going to be excluded. And so when you fill out that application for a claims-made policy, you have to put your thinking cap on and make sure that anything you know about or have a good faith belief that you should know about is being disclosed, so that you, A, don't lose your coverage entirely for misrepresentation on an application, and B, don't have something that you know is going to be excluded later. Now, if you didn't have knowledge of it, and that's going to be probably investigated by the insurance company, and presumably you'll be able to demonstrate that, then it should be covered. And if it's a company that you've had for many, many years, it may very well be that something came up during one of the prior policy periods and coverage will be easier. So the key thing here is prior claims, prior knowledge is going to potentially cause a problem with coverage before the inception of the policy. And once the policy is completely expired and the extended reporting period has expired, if you have not notified the insurance company of any claim by then, you're not going to have coverage for it, particularly not under that policy.